She told me that if anything will happen to her, that give the envelope to the police. She was afraid that he put something in the drink.
If Mr. Jensen had talked about harming his wife, is that something that you would have remembered?
Absolutely. Mark was standing 5 feet from her casket, laughing and joking and acting like someone's at a cocktail party.
That's when he said he rolled her over and just sat on her back and pushed on her neck into the pillow.
Do any of these findings suggest to you that this was a suffocation death?
Not really.
What did she say to you?
Well, she was scared that she was going to die.
That was 2008, right here on Court TV. That man, Mark Jensen, was convicted of murdering his wife. That conviction was overturned. He's now being tried once again, and Court TV's Michael Ayala has the story.
Is it my understanding that you have reached a verdict? Is that correct?
Yes. We, the jury, find the defendant, Mark D. Jensen, guilty of intentional homicide of the first degree as charged in the information.
Mark Daniel Jensen was found guilty of his wife's murder in February of 2008 and sentenced to life in prison.
If this case ever comes back, I'll try the damn thing again because Mark Jensen belongs in prison.
And the case did come back. After years of legal battles in the Wisconsin Supreme Court, Jensen was granted a new trial. Only this time, it would exclude a letter written by his wife. And prosecutor Robert Jem Boyce kept his word, returning to prosecute Jensen a second time for the killing of his wife.
The idea of a hung jury just stuck sideways in my throat because then there's no closure for anyone. And after almost 10 years, there had to be some closure.
Jensen was convicted on evidence that included a letter from his wife, Julie, who wrote before her death, "If anything happens to me, Mark would be the first suspect." Now, a new jury will hear the evidence against Jensen, but his wife's letter cannot be introduced this time around.
She had the envelope in her hands, and she said if anything happened, I should give this to the police.
The reason why the letter is the source of numerous appeals is because Mark Jensen's attorneys are not able to cross-examine Julie Jensen, who wrote the letter, because she's dead.
The prosecution claims Jensen killed his wife with antifreeze in order to be with his mistress. Prosecutors argued his internet search history provided evidence that he was looking for ways to make Julie's death look like a suicide.
Do you remember who started complaining about whose wife first?
You know, I think it really was Mark. Mark told me if you wanted to get rid of your wife, that you could go to websites that would tell you how to poison your wife, how it would not be detectable.
Jensen's attorneys argue Julie was depressed and killed herself and framed her husband out of spite.
What was your understanding as to why Mrs. Jensen was coming in to see you?
She was very upset, and it seemed like she was there because she wanted some help. She was upset enough that I gave her medicine and strongly encouraged her to seek counseling as well as to follow up with me.
A case that began 25 years ago will have one final day in court, with 125 witnesses expected to take the stand to determine whether Mark Jensen murdered his wife back in 1998.
She died in 1998. He was convicted in 2008. It was overturned, and here we are in 2023 trying the case again, but without that letter. But instead of the letter, prosecutors introduced something else. It's a manuscript written by the defendant himself while in jail. Amazing. Here's the problem that he has with the manuscript is that in it, he references the letter that now can't be used against him. It's referenced in the manuscript. So I guess the jury will kind of know about the letter now. Unbelievable. They don't catch the smart ones, folks. But there's another part to this manuscript, and that's what I want to talk about here, is that there's other information that he writes in this manuscript that really puts his wife in a bad light. It's kind of like, dirtying up the victim, but it's evidence being put in by the prosecution. Included in this manuscript are some lines written by this defendant alleging that his wife wanted to be a surrogate mother for his brother, for her brother, but wanted to get pregnant the natural way, without a petri dish. Did you follow that? He's writing down the manuscript that his wife wants to carry her brother's child and get pregnant the natural way, not with a petri dish. Let's bring back to the think tank. Charles Middlestat, Molly Palmer, Noah Pine still with us. I think it's worth getting the letter in through that manuscript.
And the whole thing comes in, Vinny.
Yeah, the whole thing is in.
The whole thing, right.
The whole thing is in. So what does the jury do with that? What does the jury do with this surrogate baby versus the letter?
I mean, the whole manuscript, look, the guy was serving a life sentence. You're going to do things to occupy your time. I assume his defense is going to be like he was writing a book or he's writing a movie or he was literally killing time since he's serving a life sentence, and none of that is reality. That's what
freedom of expression.
Yeah, it's certainly
But it is reality, because she did write the letter.
But the letter's not coming in, and you talk about a classic prosecutorial error. Why are we retrying this case so many years later? Because of a really bad decision by the prosecutor. I mean, at the end of the day, everyone knows you have a Sixth Amendment right to confront your accuser. And if you follow the case law, all of the litigation, it went through federal court, it went all the way to the Wisconsin Supreme Court. Basically, the court said, we think it was error for this letter to have been introduced. That was always the ruling. But then what it came down to was whether or not it was harmless error or whether it truly changed the verdict. And ultimately the court found that it did, because the prosecution relied so heavily on it. Closing statements throughout their case, all they talked about was the letter. Now we don't have that. I think it's a totally different game.
Hey, does he walk? Could he possibly walk out of that courtroom?
I mean, anything's possible.
It's not easy to try a case 20 years later for either side. I mean, it's difficult.
So what does the defense do 20 years later? Is there any reinvestigation?
I mean, you certainly would want to reinvestigate as to whether you can find some of these folks, whether they're still alive, whether they still have any memories or their memories have changed and all that. That's the obviously the object of the investigation, to make that determination. But, in addition to that, there's 3 witnesses that are no longer available, right? It sounds like 2 lay witnesses, 1 police officer.
Got some videotape that we're showing the jury, though.
Okay,
because
yeah, but that's the thing is
Court TV was there the first time, so we got him on video.
Right, but now it's almost like
another good reason for cameras in the courtroom, right?
I agree. I like cameras in the courtroom.
So you can re-prosecute these defendants.
Yeah, but it seems like it's a disadvantage for him, right? Because the cross-examination presumably wasn't that successful, and now he's sort of married to that same cross-examination because he can't confront these witnesses.
Do you think the jury at all will take into consideration the time that he served already and say, even if we find a reasonable doubt, he's already been punished as some strange form of a potential compromise in all of this?
I mean, go ahead, Molly.
Well, I don't know. I think that it's taking a long time to even get a jury for this case because so many people know of the Jensens. And so hopefully, I mean, if it is a fair trial, then no, they're not going to know that, right? They're going to come in without any preconceived ideas.
It's a fair trial.
Right.
Everyone's going to know.
You're always saying if they get a fair trial.
It's only the Constitution.
Okay.
That's all it is.
Everyone's going to know there's a prior trial from the prior testimony from the trial.
But they can't bring in the fact that he's serving time in deciding whether or not the prosecution proves their case. That's not a fair trial. You have to come in there and listen to the evidence and the testimony before you that's not going to include this letter and then make the decision.
I was trying to help him out. I think it helps
him
out a little bit that he served time already.
Because the jury may say, I'm not 100% sure, even though I don't have to be 100% sure. And we know he's been in prison for 20 years, so he's done his time.
Particularly if they're sort of on the fence with the evidence, right? If they're not completely convinced and they're like, look, we don't feel like he's already done time. If we make a mistake, it's not like we're letting a free man go. He's already served some time. And I think it gives them a little more freedom to err on the side of caution.
As a former prosecutor, I'm a little more scared of the potential verdict in this case, because I believe he did it. I believe the wife knew that he was going to do it. I mean, she wrote the letter. She said, if somebody kills, this is the guy. She knows what's going on in that relationship. She knows the man that she married, just like Maya Miliete knows the man that she married.
Ms. Miliete did not write a letter.
She did not.
Okay.
She went to the divorce attorney and told her everything. All right. So we're going to continue following this case, folks.